Baruch atah Adonai Eloheinu melech haolam. Asher k'nishanu b'mitzvotav v'tzivanu l'suk b'divrei Torah. V'arevna Adonai Eloheinu et divrei Toratcha b'finu v'fi Amcha Beit Yisrael. V'niyeh anachnu v'tzetzenu v'tzetzei Amcha Beit Yisrael. Kulanu yodei shemecha v'lemdei Toratecha l'shma. Baruch atah Adonai melamed Torah le'emo Yisrael.
Amen.
Amen.
Baruch atah Adonai Eloheinu melech haolam asher b'cha banu mikol hamim v'natan lanu et Torato. Baruch atah Adonai noten haTorah.
Amen.
Amen.
Kev, nice to see you.
Sorry,
All right.
just there's a tech issue. Okay.
No problem. All right. So listen quickly by Rabbi Daniel Brody. 1 minute halacha. It's in Brochus 49b, Shulchan Aruch 192, section 1. And the Mishnah Brura also 192, but section 10. All right. So what we're talking about is arranging a zuman, and if one left it out. So, once 3 men have eaten bread together, they are not allowed to sit benching separately, because that'll cause them to lose the zimun. So with a zimun, what you should do is when you in the process of eating, often what happens is somebody wakes up and says, "Oh, I've got to go," and then they quickly duck. So what should happen is there should be communication very early on to say that they should at least have the bread portion prior. In other words, to check that somebody might have to leave, etc., and not drag out an extenuating Shabbos lunch to where it's almost mincha and sludash shit. Sometimes people they don't know that it's time to call it a day, which is why everybody is grateful for their 40-minute Zoom time out of the shiur. A lot of shiurs had people hostage before Zoom, just saying. So what you need to do is speak to your compadres and basically find out when somebody has to go prematurely, so that you do the zimun quickly. If you need to do individual brachas on the food, once the seudah is done, you can always do that. Second thing to bear in mind is there's certain alterations, as you know, the Baruch Hu, Baruch Shmo, you say that, and then Hashem's name you say obviously in certain parts. Now, if there are two people and somebody else hasn't benched with you, you should try and give them a kazayat, which is a matchbox size to eat of bread, so that they can join with the zimun. So why matchbox size? It's enough for them to join and say amen, etc., but not enough to necessarily make them chayiv independently. Okay. So certainly, if you don't have a zimun, benching is valid, and you don't have to do anything again. The point of it is obviously it's an added benefit. Right. Now, with that out of the way, I'm going to fly through the daf, and I just want to go through it very, very quickly, and just tell you how it's put down in the daf, and see what we can do, and hopefully finish by 9 o'clock. So I'll tell you where we are. We're on 23b2. Come learn a proof from the next Mishnah, the next section of the Mishnah, which is Sanhedrin 76b. If he stabbed the fangs of the snake into the flesh of the victim, killing the victim with the snake bite, Rav Yehuda rules him liable to the death penalty, whereas the sages rule that he is not liable. And Rav Acha Bar Yaakov said, regarding this dispute between Rav Yehuda and the sages, when you analyze this dispute, this is what you're going to conclude. According to the opinion of Rav Yehuda, a snake's venom stands within its fangs, and thus when one presses the fangs into the victim's flesh, he directly injects him with poison. Therefore, the stabber is liable to execution by the sword, and the snake is not liable to execution. The reason why the snake is not liable to execution, as we discussed yesterday, is it's an involuntary physiological act by the snake. So here we're talking not about the inciter anymore, but about where somebody picks up a snake and wants to make it look like an accident, and picks up the snake and makes sure he presses it into the person while holding the head and injects the venom into the person. Here we're not talking about the term inciter. The term inciter was merely in the beginning part of the Mishnah. He wants to make it like an accident. So, for example, what you would do is when fingerprints first came out, I joked with my dad, why doesn't somebody freeze like a icicle in the shape of a sword, find somebody they don't like, and then stab them, and then the fingerprints will melt? He said, I need psychological help. I think it was 8. But the point of it is that sometimes you want to make it look like an accident. Yeah.
You've given many examples of that, where you've needed psychological help at Alec. But anyway.
Yes, especially my selection of friends. But
now it's all on YouTube.
The thing, yeah.
There's a better one. What you do is you cook your husband a leg of lamb for supper, hit him over the head with it, or to take a frozen leg of lamb, hit your husband over the head with it, cook the lamb, invite the cops around, and eat the evidence.
Yeah, that also is. The fact that you thought about it means you've been married for 20 years. Okay, let's go on with the year. But there's been, throughout history, mankind has wanted to tonk and kill his fellow man and not leave evidence. There wasn't DNA sampling in those days, but they could see when a knife wound was direct. So what we're talking about here is not when he insults the snake, but he gets the snake's head and he gets it to pierce the person. So because the venom is within the snake's fangs, Rav Yehuda says the snake is not liable for execution because it's involuntary part of the snake's physiology, but the person that does such a thing is liable to the death penalty. According to the sages, however, basically the snake secretes its venom on its own after its teeth pierce the victim's flesh. So therefore the result is the snake is put to death by stoning and the stabber is not liable to execution. It's the opposite way around, meaning that here the snake has chosen to take it to its full level of toxicity, but the human being on his own couldn't have extracted the poison without the snake doing it. He could have given the person a nasty bite and a scare. Maybe he was just trying to scare the person to give him money. I don't know. But the point of it is the Sanhedrin doesn't want to execute people unnecessarily. And Rav Yehuda sees it as almost a weapon, no different to if somebody stabbed somebody else with his knife. So wherever we obviously give the death penalty to the person in this case, the animal itself is exempt. And whenever the human is exempt, then the animal has caused that particular death. So they're holding two different opinions on the physiology. So just one question here, a statement. The Gemara now presents its proof from this source. So if you want to say the snake is put to death by stoning and the stabber is not liable to execution according to the rabbis. Now, if you say that the mouth of the cow is treated as the yard of the damager, then why is the snake put to death according to the sages? So what it's doing is it's answering a previous question. It's trying to answer that, is the mouth of the cow considered the damaged party's yard or the damager's yard? If somebody obviously put food into the cow's mouth or the dog's mouth, mentally incompetent person. So what we're saying here is, if you want to actually turn around and have the argument that it belongs to the owner of the cow, therefore the person is not liable, why is the snake put to death according to the sages? Let the snake's master say to the victim, what is your hand doing in the mouth of my snake? So what's that basically saying is just as one does not pay for the damages inflicted by his animal on one who trespasses into his yard, so too should the snake not to be put to death for killing the one who trespasses into the mouth. So what it's saying is the very fact that we make the owner of the snake liable in such a case, or the snake liable in such a case, is proving that it cannot be the damager's yard or possession. Why? Because you can see that they've got, it doesn't extend to each other. All right, so I'll just explain to you what it's saying here. So the Gemara actually rejects the proof. It's saying in regard to putting to death of the killer animal, in this case the snake, we do not say that the victim's hand is a reason to absolve the killer animal from execution. Thus, it may well be that the animal's mouth is treated as the damager's yard, yet the animal is put to death nonetheless. So what it's trying to say is you can't use a proof of Sanhedrin when there's death. The only reason why we used the first part of the brisa is it was a case of injury, is when somebody incited the dog to bite a third party, and we wanted to know, is the owner of the dog liable as well, or is the owner of the dog not? whenever there's a case of death, the animal is naturally put to death, and it's not a case of, it's not a proof for the fact of whether it's the damager or damager's yard, and it's going to bring the following rejection. So how do you know to say that the victim's trespass does not serve to absolve a killer animal from execution? So it was taught in a brisa, if one enters the yard of a homeowner without permission, and the homeowner's ox gores the trespasser and he dies, the ox is put to death by stoning, but its master is not liable to pay kofar payment. Okay, so I just want to explain this particular case. Is that when do we pay the kofar? Do you remember there was an argument by Rabbi Tarfon and the rabbis with regards to a kofar payment? What is a kofar payment? Can anybody remind me? I mean, I know, but does anybody remember?
Is it when a slave is killed?
Good, but why would one pay the kofar? What does it mean?
No, well, it's a fixed amount that you have to pay when a slave is killed, isn't it? And it's your fault.
I know what Marco's talking about. He's talking about, I know what he's talking about, but what I'm asking is, what is the reason? Whether it's not because it's a slave. In other words, the kofar payment, does anybody else know?
Yeah, when the animal's tam.
No. The opposite. All right. So,
Not tam.
this is
no, muad. Sorry, muad. Yes, muad.
And therefore,
if it's muad, then you have to pay because then it's your fault. Then you have to pay the kofar payment as well.
But what is it, Gav? You're on the right track. You are on the right track. But what is it?
It's a living. It's like a it's all those payments in order to keep that person.
No.
Full payment.
I'm coming to you.
Okay, so Gavin was got a certain aspect.
Okay, cool.
Gavin got a certain aspect. All right, guys, I'm going to put you out of your misery. A kofar payment is a payment by rights. If your ox is muad and you've been warned repeatedly, now all of a sudden there's a real tragic offense. That ox has actually killed somebody. It hasn't injured somebody. In Shemaim, they hold you responsible as having caused the death for that person. So the kofar payment means the following. You cannot get hanoah, benefit from that animal. In other words, you can't sell that animal's carcass and get benefit when they kill the animal. That animal is killed because it's a dangerous animal. The kofar payment means that there's an argument in the Gemara whether or not it's a penalty or compensation, because you're compensating the breadwinner of the family. You're compensating the family because they've lost their breadwinner now, in a certain case. In other words, or a family member emotionally that they can never replace. So a kofar is a payment over and above things to mitigate your guilt in Shemaim. Because there's an argument in Sanhedrin as to whether the kofar payment is for the victim. In other words, because that victim's family needs compensation, or is it a penalty to the perpetrator? But the bottom line is, in Shemaim, they hold you responsible for being negligent as far as that death is concerned by virtue of your animal. And because your animal was a muad animal, in that particular case, the general rabbinic opinion is you only pay the kofar payment if your animal causes death and it's muad, because you've been forewarned. If it's a tam, there's only a particular opinion that says you pay half the kofar payment. But the majority of the rabbinic opinion says you only pay the kofar payment as a result of your guilt, because you have blood on your hands, because this was a muad ox and this ox killed somebody. So we say
it has to be muad. It has to be
muad, because then you're not responsible in Shemaim. Yeah. The whole point of it is you're responsible for normal payments of injury and other things. The kofir payment is a financial penalty that almost makes you go broke. That's how heavy it is to pay to the victim's family, because this ox was muad, you'd been forewarned, and that ox has killed somebody now. And therefore Shemaim will hold you responsible because you've got you have death at the hands of heaven. That's the term. And this kofir payment is almost financially going to make you broke, to the extent that it says like a poor person is like a dead person. You know what I'm saying? They've really, they've really got no resources left. This is meant to teach somebody a heck of a lesson. Now, is Hashem going to hold the person responsible in Shemayim to the extent of his regret and his kapora and his teshuvah and everything else? The kofir payment on its own, I don't think is enough. Just like the death penalty on its own. If a person has no remorse and they're given the death penalty, they haven't taken the opportunity to use the death penalty as a mechanism for teshuvah if they killed somebody else. That mechanism does make itself available for a life for a life, but only if that murderer takes that opportunity to make a full teshuvah. It's the same with the kofir payment. That payment will be extracted like a death penalty, whether or not he wants it or not. But if he takes that opportunity to make a full teshuvah, it will hold him in good stead in Shemaim. In terms of how much of culpability he'll have, I don't know how that is worked out. So how's that argument brought here in Sanhedrin? It's saying when you're dealing with death penalty cases, where it causes death, not damage, like the first part of Sanhedrin, the rules don't apply to injury all of a sudden, or consumption. In other words, with Shane, I'm consuming a certain amount, my animal's consuming a certain amount of your food, and therefore I have to compensate you according to your financial loss. Does that make sense? The minute you're talking about cases of death or murder or things like that, the rules of financial compensation don't apply in the normal manner. There are different rules that apply to capital cases compared to civil cases. One of the primary examples is Kimle B'dirabba Mineh, which is that the lesser penalty or compensation is waived in favor of the greater. So we learned previously in the Daf that if one killed a slave by tying him up and letting a fire get to him, and also killed a kid goat, and they're owned by two different people, and the basic thing of it is this person that killed this other slave is going to get the death penalty for killing a human being. And therefore, we learned that even though the goat also died in the fire and belonged to somebody else, the slave owner doesn't get financially compensated for the slave. The person's getting a death penalty, nor does the separate owner of the goat end up getting compensated financially for that, because the death penalty was given to him for the murder at the same act as where the damage was caused. So the laws of civil restitution and capital cases are very, very different. So what this Gemara is bringing forward is as follows. If somebody trespasses in your yard, meaning your ox is muad, but your ox is not in the public domain, and your ox then gores somebody to death, you do not have to pay the kofir payment because you were not negligent. Your ox was not in public. He trespassed and came into your premises without permission. And since since that person entered your premises without permission, they cannot hold you liable for the kofir payment. However, the ox being a damaging ox will, in that particular case, have to be put to death because it is a muad ox. So what we see here is just because there's no kofir payment in the case of capital cases, because it's trespassing in your yard, doesn't mean it has anything to do with culpability. Guys, can you unmute? I just want to see if you understand the concept.
Damon,
Kevin, yeah, Kevin?
So regardless if it happens in the private domain, if it's a muad ox, precautions still have to be taken. and it's a serious
no.
issue.
What we're saying is something different. I'm saying three different things. Point number one is that capital has different rules. And there are parts of Sanhedrin that deal with injury cases before it extends to death, and those points of law can be applied to other civil cases. That's point number one. Point number two, because capital cases have different sets of rules, when the minute it talks about death, you cannot apply those particular principles to other civil cases. That's point number two. Point number three is, in this particular case, what it's saying is that the kofir payment is waived because somebody got gored to death by your muad ox on your premises. They had no permission to be there. And if they trespassed into your premises and your ox was not in the public domain, at which you should have been watchful of your ox,
Yes,
that was muad, then you're not liable at the hands of heaven. What is the guy doing in your premises?
Okay. So
and therefore, you don't pay the kofir payment, but the ox, hang on a second, Michael, the ox gets put to death. Why? Because this is a very, very dangerous ox.
And they would have done it in the public domain. It would have done that. It would have killed someone in the public domain eventually.
Yes, but the point of it is, had it killed exactly, it would have killed somebody in the public domain. So any time an ox, even if it's tam, causes the death of a person. In the case where it causes the death of a person, even a tam ox, you still put the animal to death, because this is an animal that is a seriously dangerous animal. Okay, so what we're saying is, because you're not liable to the kofir because the person trespassed into you, is not a proof of anything in this particular case, number one. And number two, it's a capital case. It's not a civil case. And whenever it's a capital case, you can't apply the same laws of civil restitution. So the Gemara proves this contention by saying, and from where do you know to say that the victim's trespass does not serve to absolve a killer animal from execution? For it was taught in a brisa, if one enters the yard of a homeowner without permission, and the homeowner's ox gores the trespasser, and he dies, the ox is put to death by stoning by its master. Sorry, is put to death by stoning, but its master is not liable to pay kofir. Okay? Now, what is the reason that the ox's master is not liable to pay for the kofir? Because he can claim, what are you doing in my domain? Meaning the person has trespassed into his domain, so he's got no reason to be liable at the hands of heaven because he didn't do anything wrong. But regarding the execution of his ox too, he can claim, what are you doing in my domain? So what it's saying is here, hang on a second. This ox, he can have the same claim with regards to his ox. He can turn around and say, but listen, I don't have to pay the kofir because the guy's in my domain. Now you want me to kill my ox and not get hanoah, which is any sort of benefit from my ox, because you say it's a dangerous animal. Again, what was this guy doing in my domain? Why should I lose out financially? And why is this considered a crazy ox? I mean, for example, dogs are very territorial. There are many cases where if you go into a dog, listen, if somebody broke into your home, you're also territorial. Animals are territorial. They are entitled to defend their property if some thief is breaking into the house with a flashlight. So what he's saying is, listen, if I don't have to pay kofir because I wasn't responsible, because I wasn't negligent, this guy broke in. What do I have to make sure now that my ox gets the death penalty and I can't get benefit from any of the meat and it's no longer a working animal? That's not fair. He broke into my place. So the answer is as follows, right? Rather, you see from this distinction between kofir and the execution of the ox, that in regard to putting to death of the animal, we do not say that the victim's trespass is an extenuating circumstance. So what it's saying there is, the minute they're capital cases, the normal laws of civil law don't apply. Meaning you can't use the logical argument of saying, hey, there's injury, he trespassed me, it's not my animal's fault, etc. Capital cases have its own case, and therefore in Sanhedrin, it's bringing this brisa to prove that you can bring proofs in things in Bava Kamma, Bava Messiah, and Bava Basra, but you cannot bring those particular cases where there's been a capital or death penalty offense as a proof for civil litigation cases. They're two separate rule books. Okay, that's what the Bryce is coming to prove. So we've got a few minutes left. We've got 5 minutes left before Marco has to go. All right. So the Gemara records an incident in the ruling concerning it. There were these goats owned by the Tabu family that would cause damage to the property of Rav Yosef. So Rav Yosef said to a buyer, go tell their owners that they should keep them inside their property. And a buyer said to Rav Yosef, what purpose shall I go? What will I accomplish? For if I go and tell them what you, the master, have said, they will tell me that the master should rather build a fence around his own land. So, okay, this is a case where basically Rav Yosef was having his neighbor's animals that would come and damage. Abayu was the student of Rav Yosef, and he said, listen, I would like you to go and speak to them rationally and say to them, look, they need to contain their animals because their animals are causing damage to my property. So Rav Yosef basically didn't want to get involved, and he said, if I go and tell them that the master said that they must build a fence, they will tell me that if you're worried about my animals going into your property, then you need to build a fence to protect your own property. Incidentally, by the way, Rav Yosef was the correct one halachically, because the onus is on the animal's owner to restrain his animal, not the landowner to fence his property. So guys, just an interesting halacha is that it's the animal's owner's responsibility to restrain the animal and not the landowner to fence the property. So that is why the animal's owner must pay if she eats what's inside the shop or on the sides of the street. That was in 19b. And we do not say that the damaged party should have protected their goods. It was just, so that's just a halacha that we actually learn from Sanhedrin. So it brings this case in Sanhedrin. I'm just going to carry on. We've got a few minutes left. 23b. And the Gemara challenges a buyer, but if he, the landowner, would be required to fence his property, how would you find a case where the merciful one in his Torah obligates a person for damages done through the shame of his animal? So what you're saying is, yeah, okay, Rav Yosef might be correct, but then when would you ever have a case of shame? You would never have a case of shame. In other words, if everybody had animals, protected their property by having a fence around it, when would you ever have a case of shame occurring? Am I correct? That's what the Gemara says. It wouldn't occur. So it brings two cases. It says, you'll find where the animal burrows under the fence of the property. Like say, for example, we learn that dogs burrow under a fence in order to get meat with that previous case in this particular Mishnah. Or we learn a case where if a fence fell down in the middle of the night and the animal trespassed. So we were saying, obviously, a case, if you fail to put up a fence, you are responsible. And then the Gemara responds and says, but then you'd never have a case of shame because your animal would never trespass. And it says, no, you still have an obligation to put up a fence. If you didn't, you must pay if your animal causes damage. If you send forth your animal in the field of another, you must pay. If the fence fell down in the middle of the night, you must pay. And if your animal burrowed, you must pay. And these are cases that would happen. So it says you'll find where the animal burrows under the fence of the property, or else you'll find where the fence fell down during the night and the animal entered the property before the property owner became aware that his fence was down. Okay. So just, I need exactly 2 minutes and then we're done. We're actually done. A related ruling, Rav Yosef and some say Rabbah issued the following proclamation. Those going up from Babylonia to Eretz Yisrael and those going down from Eretz Yisrael to Babylonia should know the following law. If these goats of the meat market cause damage, we warn their owners about this 2 or 3 times. Okay? If the owner heeds the warning and restrains his goats, fine. And if he does not heed the warning, we say, sit at the butcher's place and take your money. So what is this talking about? There are certain times of the year that you go from Babylonia to Jerusalem and you make sacrifices. So they say if your goats cause damage, we're not talking about a muad and tam. We say these goats are going to be a problem because they're coming. Huge amounts of people go from Eretz Israel to Babylonia and vice versa. And if people are traveling and these goats cause damage, but these are goats that are going to be sacrificed at the meat market. Just bear in mind one thing. They had no refrigeration in those days. So what had to happen, Rabbi Cohen explained, is that you would have to kill the animal pretty close to the time. The animal would have to be shechted pretty close to the time when the markets would open up. I got the impression that the meat market wasn't opened up every day for every meat product. I got the impression that Tuesday would be goat day and Thursday would be goat day and maybe Monday and Wednesday would be beef day or something like that. But if you had your animal killed and there was no refrigeration, your meat would go off relatively earlier in terms of decaying, and therefore you wouldn't get the meat value. So what it's saying here is as follows, is that we learn a halacha that if your goats cause trouble and they were destined to die anyway, you have to kill them prematurely as the penalty for causing damage and then sell the meat to the person you damaged. And even if you lose a bit of money because you didn't get the full value of your meat by selling it early because there's no refrigeration, you have to take the hit because you mustn't trouble the damaged party for going to court because this is an animal destined to die anyway. If this was a working goat, at which you weren't going to take it to the meat market and you weren't traveling from Eretz Israel to Bologna or vice versa, you don't have to kill the goat prematurely, and you only have to pay for the damage on the on the fourth offense. This goat, at which you warn 2 or 3 times, are goats already scheduled to be shechted anyway. They're just shechted a few days premature if they become troublesome, and you take a little bit of a loss. Okay, because we don't want to trouble the courts. That's all we learned. We're done, guys. We're done.
Thanks, Dan.
All right, guys.
Thank you. Thanks, guys. Have a good day.
You too.
All right, guys, just stay on for a minute. I know Marco has to go.
Yeah.
All right, cheers, Marco.
Cheers.
Damon?
All right, guys, do you have questions?
Yeah.
Talk to me.
The snake, you were saying earlier, so you get distracted from time to time. When you said that somebody puts his hand in the mouth of the snake, but the mouth is the snake is considered the snake's the private domain, like we were talking about the dog a while ago.
What we're saying there is as follows. There's 2 different cases in Sanhedrin. The first case is when you incite a dog or a snake to bite somebody, and that animal bites that person of their own volition.
Okay.
In which case the inciter is not liable. The second case is when he doesn't want to be caught stabbing the victim, so he takes a snake there because he's
grabs it around the neck.
The snake and makes sure it pierces somebody and hopes the snake will stick in enough venom to render this person dead. And in that particular case, Rav Yehuda says that that person is liable to the death penalty if the person dies, because the snake's venom automatically comes out of its fangs enough to kill a person. It's an involuntary act, and therefore we don't kill the snake, but we kill the person because it's normal. It's not the snake's fault. The snake never got incited, and
he turned the snake into a weapon, like it's as if he was holding a knife for him.
Beautiful, beautiful phrase. He turned the snake into a weapon. That's exact commentaries of the Gemara. It's exactly what he did. So therefore, it's no different had he stabbed the victim himself. That's correct. And therefore, you can't stone or put the snake to death. The snake did nothing wrong. But according to the rabbis, that the snake has got a choice whether or not it wants to insert or inject enough toxin or not to kill a person. So therefore, the rabbis say that it would be enough to injure a person, but not enough to kill a person unless the snake decided to inject enough poison. And therefore, if that person died, then the person using the snake would not get the death penalty because they don't hold, the rabbis, that the snake has culpability enough for a lethal dose by somebody just taking the fangs of that. They're saying if the person picks up a snakehead and goes like that, that won't kill a person. It will puncture a person. But it's the snake who can choose whether or not at that point to release toxins or not. It's not an involuntary decision on the snake. Therefore, the person has merely pierced the skin of his fellow, doesn't get the death penalty, sure pays for injuries, and the snake gets the death penalty because it's the snake that chose to follow through with the toxin. So that's it. It's just talking about two different cases. The whole reason it brings this is it wants to determine if somebody puts something in the mouth of the animal, is it the yard of the damaged party or the damager? And we're saying with capital cases, it's no proof either way. And with injury cases, we learned before that we don't hold the owner of the animal liable for the dog bite. Therefore, if third party does the damaged party's yard. Does that make sense? And then the counter opinion was that it's not considered his problem because there was somebody that incited his animal and he wasn't involved. So that wasn't a conclusive proof either, by the way. So there were two opinions. What were you going to ask, Kev?
If the dog bites, if the dog, the owner's not liable. If the dog bites, then can the dog be? Are there cases where the dog can be killed or stoned because the dog?
Yeah, we did learn cases in Sanhedrin where the animal was put to death. If it's a muad animal, I think we learned that on 19b. I think. Remember where we said but we said what happens if the value of the animal? We were talking about a chihuahua was worth. We're not going to sell chihuahua meat was worth less than the injury. Remember that whole discussion? And I said nobody's killing any chihuahuas here. So we did discuss the circumstances at which an animal was killed or not. Guys, it's been lovely to see you.
Thanks.
I'll see you tomorrow, please. Pleasure, guys.
Cheers, man.
Ciao, man. Cheers,
Thanks.
off.
Cheers, guys.